All right, so let's start the session. Good morning to everyone, and hello and welcome to Unacademy. My name is Aditi Bhatt, and I'll be taking your session on daily legal current affairs, wherein we will be analyzing the Hindu newspaper for today. And you can join my Telegram channel for regular updates. The Telegram link is given here, and it will also be pinned in the comment section below. And you can also use the barcode for joining the Telegram channel. Also, if you're planning to take in on any of the subscriptions offered by the Unacademy platform, then to unlock free classes and subscription discounts, you can use the referral code ABCLAT. All right, so let's see the highlights for today. The first news item that we will be covering today is the crisis in Manipur is a humanitarian problem. This is said by the Supreme Court. The second news item, it basically states that the Election Commission has recently, warned Congress or has sought clarification regarding a tweet on sovereignty. So we'll discuss that. And then the third news item basically states days after assault in a Delhi hospital, woman dies. So we look into the provisions of IPC related to the offense that has been committed. Then an unacceptable state of affairs. High Court on Tillu killing. So we all know that there was a mob, there was a gang war, and because of that, there was a murder inside the jail, right? So we'll also look into that aspect as well. Then the fifth news item talks about Haryana government announces reservation for backward classes in urban local bodies. We look into the urban local bodies reservation and the election, right? And the sixth news item basically states Hyderabad woman among 9 persons killed in Texas shooting. So we'll be doing a comparative analysis between the Indian arms laws and the US arms laws, and basically just in a brief, just so that you are aware of what all is there. Then when In the seventh news item, we will be covering High Court does not have power to direct changes to scheduled tribe list. The CJI, the Chief Justice of India, has recently declared that. And the eighth news item basically states that Iran hangs 2 men in rare blasphemy case as executions surge. Okay, so here we'll be doing a comparative criminal law analysis, right, between Indian criminal law justice system and the Iranian. All right, so let's start with the session. The first news item: the crisis in Manipur is a humanitarian problem. This is said by the Supreme Court. The Supreme Court on Monday called the Manipur crisis a humanitarian problem, while noting that it is the president and not the High Court who has the power to designate a community as scheduled caste or scheduled tribe, right? So it is the president who has the power to designate a community as scheduled tribe, and not the High Court. Let me just mark it here. All right, so just so that you can visibly read it, just a second. Here it is written that president and not the High Court has the power to designate a community as scheduled caste or scheduled tribe. So it is the president that wields the power of, as per the constitution, to declare a particular community as scheduled tribe or scheduled caste. All right. Okay. We have made our concern explicit about the need for protection of people and property, and the need for restitution and stabilization. This is a humanitarian problem. We are concerned deeply about the loss of life and property. So here, as you can see, the word humanitarian. So I really wanted you all to know what, although this is a segment of public international law that you will be covering in your law school itself, but you just need to have certain idea as to what is humanitarian law, what is international humanitarian law, and how international humanitarian law is also applicable on domestic humanitarian crises. Okay, so if there is a crisis, or if there is a humanitarian crisis in a particular region or within a particular community, right, even that would be a humanitarian, it need not be an international level crisis. Okay, so first of all, let's understand what is IHL, or international humanitarian law. So IHL is a compilation of, or the international humanitarian law is a compilation of rules that aim to mitigate the humanitarian consequences of armed conflict, right? So it protects those who are not or no longer engaged in hospitalities. So it basically protects, the law basically protects those who are no longer, or who are basically, who are not uh, who are not engaged in hostilities. That means, let's just say, if there is a war situation going on, if there is a war going on, then the people who are, let's say, the civilians, the doctors, right, the people who are basically not engaged in the warfare or in any kind of hostilities, right, those are the people who will be protected under the international humanitarian law. And when it, obviously, when it applies to a domestic region, then of course it protects those civilians and the unarmed population, or the people who are not engaged in any kind of hostile activity, people who are not taking part in the protest, or people who are not directly, participating in any kind of such, because they are unarmed, and they are not really directly related to it. And so the international humanitarian law, or let's say the humanitarian law, protects those who are uh, the general civilians, okay, the civilian population, you can say, the civilian population. Okay, all right. Now, this is also known as the law of war or law of armed conflict. This law is based on rules of ancient civilizations and religions, and warfare has always been governed by certain principles and practices. As the international community developed, a number of governments have contributed to the formulation of those rules. Today, international humanitarian law is regarded as a universal law, and it extends to armed warfare, right? And it can also be extended to domestic region, not just internationally, right? So it protects all those individuals who are not taking part in any kind of conflict, such as civilians, medical staff, right, or any kind of religious personnel, right? So those people are basically protected under this law. All right. So, and what is the word that we see here is that humanitarian crisis. Now, COVID was also a humanitarian crisis, okay, but it was at a at a large scale, right, wherein the global population was affected. It was perhaps, COVID has been perhaps the largest in this century, largest sort of humanitarian crisis till now in the century. One of the, I would say, one of the largest. But yeah, COVID, because it affected everyone throughout the globe, across the globe, right? So, what is humanitarian crisis? Humanitarian crisis is a generalized emergency situation that affects an entire community or a group of people in a region. Yeah, it can affect an entire, it affects an entire community or a group of people in a region. Right now we're talking about the Manipur, the state of Manipur. Yeah. Um, all right. So this is what I wanted you to understand with respect to this particular news item. Okay, because the Supreme Court has specifically, used the term humanitarian. So it will be good to understand. So now, and you need to also distinguish between the term humanitarian and human rights. So these are also different. Okay, so there is actually a difference between public international law, international humanitarian law, and human rights law. These three are three different segments, and right, and there is also a difference between private international law. So okay, so all right, so you please keep that, and you can take note of that. All right, next is election commission. Now, Election Commission has sought clarification with regard to a particular tweet made by Congress Party on the term sovereignty. Now, Congress basically, used the term sovereignty with respect to the state of Karnataka, right? They have used the term sovereignty of the state. So, whether the term now, Election Commission has sought clarification on this particular line used by the Congress party. Now, sovereignty of the state in India, or basically, what the first we need to understand what is the concept of sovereignty. So, what is sovereignty? Sovereignty is basically full right and power of a governing body over itself without any interference from outside sources or bodies. Okay, so it is like a full or complete power and right, yeah, of a governing body over itself without any interference from outside sources of bodies. In constitutional law, where have you read the term sovereignty? So the term sovereignty is enshrined in the preamble itself, where when it is basically defining the the indian state nature of the Indian state. So when in the preamble you'll see that India is a democratic republic. India is a sovereign, yeah, sovereign, socialist, secular, right? So the term sovereignty is basically used with respect to a country or a nation, right? It is used with respect to a nation. So a country can be sovereign. The constitution lays out the position wherein the people of India have resolved to constitute the Indian Republic into a sovereign country. No country can exercise sovereignty by being isolated with other countries. It has to engage and collaborate with other nations under the defined set of international laws. Also, according to there is an international convention, commission, international commission on intervention and state sovereignty. It basically states that national political authorities are responsible to the citizens internally and to the international community throughout the United Nations. It is appropriate to say that an authority's right to sovereignty is not unfettered. Right under Article 1. So first we need to understand why the Election Commission has sought clarification now. What is the whole confusion about? The whole thing is that this word sovereignty is used for country. That is, it can only be used for India and not for any state, right? And why is it so? Now we'll have to look into Article 1 of the Constitution. Article 1 of the Constitution of India. This basically states that India, that is Bharat, India, that is Bharat, is a union of states. Now, when I say union of states, it does not mean that we are a unitary system, right? We are not following a unitary system of governance, or we are not really a federation, right? It's the constitution is federal in nature. Our constitution is federal in nature, or basically it has both the features of federal as well as unitary. So the correct term for our constitution would be quasi federal, right? Quasi federal. And according to Dr. B.R. Ambedkar, the phrase union of states means it has been the phrase union of states does not mean federation of states. ठीक है तो जो when you compare the Indian Constitution with the US Constitution, you will see that the word federation of states has been used in the US Constitution, but in the Indian Constitution the word union of states has been used. इसका क्या मतलब है? The word, the phrase federation of states basically mean two things. Firstly, the Indian Federation, or the word union of states basically means the Indian Federation is not a result of, is not the result of an agreement among the states. So the states have not really come together and formed an agreement. Right? This is the Federation of States is it can be related with the US Constitution. However, in Indian Constitution, the second reason is the second point is that the states in India, as per the Indian Constitution, the states have no right, to secede. Secede. So the word secede basically means to separate. Okay? To the states have no right to secede from the federation. Yeah. So the federation is a union because it is indestructible. The federation is a union. Why do we say union of states? Because it is indestructible. And there is a very famous line used, indestructible. Right? There is a very famous line that is generally used. So India is rightfully described as, I just write it here. India is described as an indestructible union of destructible states. An indestructible union of destructible states. What does this mean? Now, when you read Article 1, Article 2 and Article 3 of the Constitution together, you'll get what I'm trying to say. So, I'll just explain it in fact. So, the Parliament, as per the Constitution, the Parliament has been given the power to, create or destruct states, right? Parliament can add new territory to the Indian state. ठीक है, नई टेरिटरी को इंडियन टेरिटरी में ऐड किया जा सकता है, but the territory which is already part of India cannot secede from the Indian Union or cannot separate. उसको हटाया नहीं जा सकता, right? So the union is indestructible. The union is indestructible, but the states, तो जो regions हैं, उनको parliament can actually destruct and reconstruct the states according to with time, okay, according to its convenience, basically administrative convenience के लिए. जब पहले इंडिपेंडेंस हम लोग को जब मिली थी, at that time the number of states were quite less, and the whole, it was basically different. There were several states which were not present at the time when India got independence, right? And the Indian government basically, Article 3 of the Constitution gives power to the Union government, or the Parliament rather, to create new states, merge two or more states. So the Parliament can create new state, right? जैसे यूपी में से उत्तराखंड निकला, right? Then you'll see MP, sorry, बिहार में से झारखंड निकला था, and उड़ीसा में से और MP में से छत्तीसगढ़ निकला था, right? So you'll see these three states were formed, right? And these three new states were created. Similarly, states were merged, right? So the union government or the parliament can actually merge two or more states or union territories, like Daman and Diu and Dadar and Nagar Haveli were two separate union territories which were merged for better administrative convenience. सो जो भी कल अगर पार्लियामेंट डिसाइड करती है कि कर्नाटका को दूसरे किसी स्टेट के साथ मर्ज करना है, तो इट कैन एक्चुअली डू दैट. All right, so the states are actually destructible. So states cannot secede from India, or if tomorrow the parliament decides to break Tamil Nadu into 5 different states, it can also do that. So I'm just giving you an example that the Indian, or the Indian Union of States, or the Indian Federation as we can say, is an indestructible union of destructible states. This is what you need to understand with respect to this particular news item, and I hope this was clear. All right, so we'll move ahead to the next news item, that is, days after assault in Delhi hospital, woman dies. So this is basically a case. This case was registered under IPC. This case was registered under IPC sections 376, which basically deals with rape, or 376 deals with punishment for rape, and section 323, sorry, which deals with punishment for voluntarily causing hurt. Okay, the lady basically succumbed to death, and we look into the IPC provisions related to this. All right, so under IPC, section 375 deals with rape. Section 376 deals with punishment for rape. No, and yes, just for clarification, for CLAT, you do not need to remember the sections. It is just for your information I'm telling you. Right? The rape is basically covered under offenses against human body under chapter 16 of IPC, deals with offenses against human body. उसमें कई सारे offenses आते हैं, hurt, grievous hurt, right, assault, criminal force, right, and of course rape. Okay, offenses against human body. So sorry, I'll just punishment for rape. Sorry. All right. I had written CLAT because I was talking about the section. So, okay, right. No, now the section, the particular chapter basically discusses offenses affecting human body under the headings of sexual offenses. Now, the punishment for committing rape is defined under section 376. Um, Under Article 21, you will see that under Article 21, you have the right to life guaranteed under Article free and dignified life guaranteed under Article 21 of the Constitution. And which is why, when it comes to rape cases, the legislature has selected rape cases to be directly triable by the highest criminal trial court, which is the Court of Sessions. So, Court of Sessions are the highest criminal trial court. So the rape cases can be directly, entertained in the sessions court. Now, India has witnessed some gruesome and tortious sexual uh, crimes against women, like we all are aware of the Nirbhaya gang rape case, the Hathras gang rape case, and the Katwa rape case, right? Shakti Mills case, the Dr. Priyanka Reddy gang rape case. So there are a lot of incidents. There are a lot of n number of cases actually related to the crime of or offense of rape. And so we'll see what section 376 deals with. 376 provides for statutory punishment for the offense of rape. In the first section, it provides whoever commits the offense of rape shall be punished with rigorous. So what is the punishment? Punishment for rape is rigorous imprisonment. So under IPC you will see different types of punishment. Okay, under IPC you will see first is capital punishment, which is the death sentence, capital punishment, right? Then you will see the imprisonment. Okay, and imprisonment is of two types. First is rigorous. All right, and before just a second. So the capital punishment is the highest degree or the highest order of punishment awarded. Below that comes the life imprisonment, right? Then you'll see imprisonment. Under imprisonment, you will see three categories of imprisonment. First is rigorous imprisonment. Then you'll see simple imprisonment, and there's also solitary confinement, which is given for only for a specific period. Solitary confinement, which is given while in within that imprisonment only. Okay, solitary confinement is basically part of the rigorous imprisonment itself. Solitary confinement. Then another kind of punishment is fine and um, any kind of forfeiture of property. Okay, so these are the different types of punishments given under IPC. So for the punishment for the offense of rape, uh, the person whoever commits the offense of rape shall be punished with rigorous imprisonment, which shall be not less than 10 years. So minimum 10 years, right? 10 years or plus, right? And would be liable for fine as well, plus fine. So rigorous imprisonment plus fine. And then there is subsection 2 which talks about, so this was subsection 1 of section 376, and the second subsection basically talks about uh, punishment for rape for specific individuals who commit rape in certain circumstances. Okay, so when the rape is committed by a police officer, it then talks about a rape committed by public servant. Also it talks about rape committed by an armed forces personnel, right? Then rape committed by a staff or management of a custody place or a jail, remand home, women's or children's institution, or a commission of rape on a woman in a hospital, commission of rape on a woman in a hospital by a member of the hospital staff or management, by hospital staff or management, right? So this particular the sixth subsection basically applies to this particular case. Also it talks about section 323. So section 323 basically provides punishment for voluntarily causing hurt, right? It is also covered under the same chapter of the IPC. And the punishment basically is so voluntarily causing hurt is given under the offense is covered under 321, for which the punishment is awarded under 323. Punishment is imprisonment or simple, so simple imprisonment or rigorous imprisonment, all right, extending up to 1 year, extending up to 1 year, uh, and along with fine, or with both. So it is or fine, with or without fine basically, right? Or both. Okay, so this is basically what the sections of the IPC deal with in this particular news item. All right, so we'll move ahead to the another news item. An unacceptable state of affairs, High Court on Tillu killing. So this is Tillu Tajpuria case, Tillu Tajpuria murder case. This murder was committed inside the Tihar jail by another convict. So, like one convict murdered another convict. Okay, both of them were under sentence. All right, they were serving sentence, and they were gang rivals. And so this is but this happening, such an incident taking place in a jail is unacceptable state of affairs. This is what the Delhi High Court says, right? And generally, we talk about custodial violence and death. This is custodial violence. In generally, when we talk about custodial violence, that is violence or death that has taken place in the custody of police or inside the jail premises. We generally refer to the public authorities causing the custodial violence or death. But in this case, this will also be categorized as a custodial violence or a custodial death, even though in this case the murder has been committed by another convict, okay, another person who was serving sentence. So So custodial deaths refers to death of persons who are serving sentence. Okay. Now this is custodial death basically refers to death of person who was serving sentence. That is, they were inside the custody of the jail authorities. Custody, right? They were serving a sentence. Or it can also relate to death of a person. So custodial death basically refers to either the person is in police custody, right, or in judicial custody, or while undergoing, that is judicial custody while undergoing trial, or an under trial prisoner, under trial prisoner, or a person who is serving sentence, was already a convict serving sentence. That means that person has already been convicted. So convict. Okay. Custodial death is a death that occurs while a person is in the custody of law enforcement officials or in a correctional facility. It can occur due to various causes, such as, generally, it is referred to abuse by authorities, but in this case, it will be just, act of murder inside, murder by a convict inside the jail premises, in this case. All right. Okay, so we'll move on to the next article. In this particular article, the Haryana government has announced reservation for backward classes in urban local body elections. Okay, so urban local body elections, the Haryana government has in the urban local bodies. So the Haryana government has announced reservations, right? So let's see. Basically, Supreme Court has in various cases, there have been a number of cases. In some of the cases, Supreme Court has basically laid down a triple test for OBC reservation and urban local body. So Supreme Court has laid down triple test for OBC reservation in urban local bodies. What are those three tests? Firstly, the data to be made available on the backwardness of the OBCs in every local body. So the state has to ensure that the data is made available on the backwardness of OBCs in every local body. Secondly, that total reservation does not exceed 50%. So the total reservation should not exceed, total reservation means the reservation of SCs, STs, and OBCs taken together. Okay, so the 50% benchmark. And the third is that the state also needs to specify. So the state will also have to specify the proportion of reservation in each local body. In each local body. All right. So Article 243T of the Constitution. Article 243 capital T of Constitution of India provides for reservation of seats in urban local bodies. In urban local bodies. Seats are reserved for the scheduled caste, scheduled tribes, and other backward classes in every municipality. Not less than one third of the total number of seats reserved for women. Right, the office of chairpersons in the municipality shall be reserved for the scheduled caste, the scheduled tribes, the OBCs, and the women in such manner as the legislature of the state may by law provide. For the OBC reservation, you will see there are different commissions. We have the Kalelkar Commission, which was the first to identify backward classes other than SCs and STs. So we have I'll write it here, Kalelkar Commission. Okay, this was the first first to identify backward classes other than the scheduled caste and scheduled tribe at the national level. And then we had, of course, the famous Mandal Commission. Mandal Commission in 1980. This was Kalelkar was in 1953. Mandal Commission was in 1980. Okay, it provide it provided 27% of reservation of seats in union civil and civil post and services for OBCs. That is Article 16 Clause 4. Okay, so 27% reservation for OBCs, right? And 102nd, now this is also important from your exam point of view. 102nd Constitutional Amendment Act. So 102nd Constitutional Amendment Act provides constitutional status to, it provided constitutional status to National Commission, to NCBC, that is National Commission for Backward Classes. National Commission for Backward Classes. Okay, all right. So I hope this article, from the perspective of your exam point of view, you need to know certain details. All right. Okay. The next is Hyderabad woman among 9 persons killed in Texas shooting. Now this particular article basically I will not exactly categorize it under constitutional or criminal law, although it is related to both constitutional and criminal law. This lady was killed in Texas. So here I want to just little bit talk to you about the Indian law with respect to weapons. So the Indian arms law right? We have the Arms Act in India and the US arms law, or they have specific arms law in different states, but in general I want to talk about the US, what US Constitution states. So basically, you need to understand that in India, only like it is not that easy to carry an arm, right? It is not a right to carry an arm in India. In India, only the authorized, only if someone is authorized to carry arms, only that person will be allowed to carry arm. This is regulated. So the entire who can get license, who cannot get license, all that is related to weapons or any kind of arms is basically uh, that is regulated by, just a second. Yeah, so we have the Arms Act of 1959. So in India, this particular act regulates or regulates all kinds of arms and ammunitions, right? It basically curbs any kind of illegal hoarding of weapons or illegal weapons and violence stemming from them. So all of that is regulated in India via Arms Act. In India, it is not a right to carry an arm or a weapon, right? But in US, and of course, when we talk about the Arms Act, in Section 25 of the Arms Act, basically punishes anyone for carrying or illegally possessing or carrying any particular arm, and it has a whole list of details. So we need not get into that, but we just need to understand that in India it's not that easy to possess or even carry arms. But in US, access to guns is controlled by law under different federal statutes. Under under the US Constitution itself, the right to keep and bear arm, the right to keep and bear arms is protected by the Second Amendment of the US Constitution. US Constitution, right? So, in United States of America, it is basically a right to keep and bear arms, right? People can keep guns or people can keep arms in their home itself, which is actually nowadays has caused a lot of problem. Um, the arms, of course, the regulation of arms and everything is regulated by different state statutes. There over there, the various states have their own laws related to arms, possessing arms, or carrying of any kind of weapon or arms. But this has caused a lot of problem, because uh, arms are basically you are giving guns, or you're giving normal people, the civilians, the right to keep guns, and then they are using it in all sorts of ways. So that is why a lot of killing, this is not just one incident, a lot of killing has happened in like past several years. It has been happening, right? And so this again is a this is again another incident which has occurred related to, which is basically showing the mirror to the US Constitution, that how, why is it still a right, and whether it should be looked upon or not, whether they should reconsider changing or amending. Although it is very difficult to amend the US Constitution, but still that's because it's creating a lot of issue over there in United States, and a lot of people have died due to this particular law. All right, so just we'll move on to another article. High Court does not have the power to change or power to direct changes to scheduled tribes list. So the Chief Justice of India has So this is similar to the article that we studied in the first news item. So this is also a continuation of that. In this particular news item, the CGI has stated that it is the presidential power to designate scheduled caste or scheduled tribe, right? And he has also stated that there is a 23-year-old constitutional bench judgment which clearly held that no court or state had power to add, subtract, or modify scheduled tribes list. This was not shown in the Manipur High Court in the first place. He is referring to this judgment of 2000, okay, which states state of Maharashtra versus Milind. This was held in November. This judgment was delivered in November 2000. This It states it is not open to state governments or courts. Here it is. Supreme Court has directed that the state government shall consider the case of the petitioners for inclusion of the Meitei community in the scheduled tribe list. Now, the Manipur High Court, sorry, has uh, basically stated this expeditiously, preferably within a period of 4 weeks from the date of receipt of the copy of this order. But the Supreme Court has stated that it is not open to state governments or courts or tribunals or any other authority to modify, amend, or alter the list of scheduled tribes specified in the notification issued under clause 1 of article 342. Okay, only the president has the power to designate scheduled caste or scheduled tribe. This was stated in the state of Maharashtra versus Milind in November 2000. It had held that a notification issued under clause 1 of article 342 specifying scheduled tribes can be amended only by law to be made by parliament. The constitution bench had held that scheduled tribes order had to be read as it is. The constitution order relating to the scheduled tribes has to be read as it is. The scheduled tribes order must be read as it is. It is not even permissible to say that a tribe, sub tribe, part of, or a group of any tribe or tribal community is synonymous to the one mentioned in the scheduled tribes order if they are not so specifically mentioned in it. Okay. All right. So I hope this was clear. Right, and now this is the final news item that we will be covering for today. Iran hangs two men in rare blasphemy case as executions surge. Now with this news item I just wanted to highlight the issue of comparative criminal law. All right, even though this news item is related to Iran, but we need to understand this news item from the point of view or from the perspective of comparative criminal law. That is, we can compare the Indian criminal justice system with that of other countries, that is in this case the Islamic Republic of Iran, right? So the Islamic Republic of Iran was founded in 1979. So Iran was founded in 1979, right? And they follow a legal code. Their legal code basically based on their legal code is based on Islamic law or Sharia law, right? Whereas in India we have a uniform criminal code in India, that is the Indian Penal Code 1860 along with Code of Criminal Procedure and Indian Evidence Act. So that's the difference. So we have a uniform criminal code in India, irrespective of any religion. Everyone, so the criminal code in India is applicable upon anyone, irrespective of religion, right? But in Iran, of course, because it's an Islamic republic, so it follows the Sharia law or Islamic law for the criminal, for this thing, uh, as the legal justice system, as the basis for legal justice system. And that's why in you'll see that in Sharia law, the execution of persons, executions, or death punishments, death sentences, or capital punishments are actually quite common, very common okay. Whereas in Indian justice system, in the Indian criminal justice system, the capital punishment is only awarded only in rarest of the rare cases, rarest of the rare cases, and that too after taking into consideration the factors, various factors, and mitigating circumstances uh, surrounding the accused, or the person who is being surrounding the person, whoever is the accused, or whoever is going to get the capital punishment awarded. So the courts, basically, it's very rare in India to award capital punishment. It is awarded only in rarest of the rare situations. For example, if there is any terrorist, so in terrorist, or if there is even in rape cases, rigorous life imprisonment is awarded, and not capital punishment. Capital punishment is awarded in those rape cases wherein the rape was conducted heinously, or in Nirbhaya gang rape matter, the convicts were actually awarded rape sentence, right? uh, in India, imprisonment or life imprisonment is the law for such matters. Life imprisonment is the rule, and capital punishment is the exception, right? So we just did a comparative analysis of both the Iranian criminal justice system and the Indian criminal justice system. You need to just have a broad idea of this. You will be eventually be studying that in your law school as well, and just having this idea about how the Indian criminal justice system works, and the issue related to capital punishment. In fact, there are several countries which have actually banned capital punishment, and there are several countries which have not yet banned. Like India is also one of those countries which have not yet banned capital punishment. But it is quite, actually there are several theories of punishment. There are 5 theories of punishment which you will be studying eventually. So those theories of capital of punishment, so there are certain theories which are conflicting, which is why so some people prefer certain theory to be applicable in criminal justice system, and therefore there that's why, like there is a retributive theory of punishment, which basically talks for or which basically states that for an eye should be given, or for a hand should be given, like that, right? For teeth, a teeth. So retributive justice system is basically, it talks about satisfaction of providing satisfaction to the victim or the victim's family, which is one of the reasons why the capital punishment has still not been done away with. Otherwise, there have been many, even now the central government is reconsidering whether the capital punishment should be banned in India or not. All right. Okay, so we are done with all the news items for today. All right, and for regular updates, you can join my Telegram channel using the link or the barcode given here. All right, if you have any questions or doubts, you can write it in the comment section below, and I'll get back to you. All right, and so thank you for attending.